All right, so federal priorities in white-collar crime. I think it's interesting, and we're going to be talking a decent amount about transitions because we've had a transition from one administration to the next. And I note you can tell that we're in a transition when it says faculty and we're listed as just U.S. Department of Justice, because at the time they arranged this, we had no idea whether or not we were still going to be leaders in our office. We're all either actings or the United States attorneys in our various offices up on this panel, and I'll introduce all of us. Not me, obviously, but we've got acting U.S. attorneys or U.S. attorneys here from 5 different districts, covering 250 AUSAs that we supervise, 3 different states. We have 100 years of DOJ prosecution experience that's up on this stage right now. The map shows the districts that we cover, all 3 here in Georgia, South Carolina, as well as the Western District of North Carolina. I represent a large, small district, the Southern District of Georgia. We've got 26 attorneys at full staff. Next, representing the small, medium-sized district of 28 and a half AUSAs is Pete Peterman. Pete, you can explain later how you have 1/2 of an AUSA.
It's me.
Pete has been in the office for 27 years in the Middle District. He's been the criminal chief. He was the FAUSA for 19 years. He's held the position of acting U.S. attorney, I believe, a number of different times. As a Director's Award recipient, I believe, and this is, I don't think in your bio, but I've been told this, Pete, I believe you sit in on every single grand jury session that's going on in your district. Is that right?
Yes.
Yeah. Handled some of the most difficult cases in the office in the Middle District, headquartered out of Macon. Before he was a federal prosecutor, was an ADA, and then was in private practice. Representing the large, medium-sized districts of 44 attorneys, immediately to Pete's right, is Jill Rose. Jill has been in the office for 18 years in the U.S. Attorney's Office. I believe in the offices both in Asheville and in Charlotte. Has handled just about every case imaginable out of that office. First, in terms of supervision, was the lead OCDEF attorney, and then the criminal division chief, and then the FAUSA, and now has been the actual U.S. attorney, not presidentially appointed, for approximately 2.5 years, which is, I guess, right after Ann Tompkins left the office. Most recently, Jill was lead on the Petraeus leak case. She was also lead on the first successful death penalty case involving an MS-13 member, which is an important priority in this administration if you've followed the news at all. Representing a small, large district. We're organized in small, medium, large, and extra large districts. And then within those designations, there's small, medium, and large. So representing the small, large district of 57 attorneys out of the District of South Carolina, also to Jill's right is Beth Drake. Beth has been an AUSA, FAUSA, and U.S. attorney for over 20 years. Out of the District of South Carolina. I think she's going on her 23rd year. I don't believe there's even been an interview in the Department of Justice of any applicant out of South Carolina. I don't think that's inside baseball. I think it's pretty well known in South Carolina. So Beth may be the U.S. attorney for a while in South Carolina. Probably has nothing to do with...
I got this.
Probably has nothing to do with Mr. Trump's like or dislike of the senators in South Carolina.
It doesn't, I don't.
She's been in every division, criminal division, civil division, appellate, been the FAUSA for 7 years, and while acting as the FAUSA, led the office's civil rights efforts. And as you probably well know, the civil rights prosecutions out of the District of South Carolina over the past years have been enormous, with the roof prosecution as well as the officer who gunned somebody down from the back. And to the last but not least, representing a large district of 99 attorneys is John A. Horn, who has been in the Northern District of Georgia for 16 years. Before that was at King and Spalding. Was appointed as the first assistant United States attorney by Sally Yates back in 2010 when he was a prosecutor. Was deputy chief of OSADEF, prosecuted international drug cartels, and also served as the appellate chief before he became first assistant. And so, like I said, there is a tremendous amount. The transition that we're in is that I believe Ms. Brand said you have 5 presidentially appointed U.S. attorneys. The rest are us, long-term prosecutors who are now leading their respective offices. And so we are in a period of transition with a new administration, a new Attorney General, a new DAG, and I will say within the next year, maybe except for South Carolina, none of us will likely be leading our respective offices. Some, if not many of us, will not be with the Department of Justice anymore. Any show of hands of who's leaving the, okay, no, I think I'm the only one with the guts enough to say that I'll be actually leaving the Department of Justice at the end of this month. Been an incredible experience for me. So I think we have a unique situation where we have career prosecutors commenting on a sort of a period of transition. And there were recently, what we're first going to talk about is the recently announced DOJ priorities when the Attorney General became the Attorney General. And immediately when the Attorney General Sessions became AG, I get all the national press releases, I get all of the speeches, and immediately the AG is talking about the uptick in violent crime, that he wants U.S. attorneys, U.S. attorneys' offices to start working more closely with state and local folks going after violent crime in your particular areas. And so when we first talked about priorities coming out of the Department of Justice, early, I would say in the February, March time period, it was violent crime, it was immigration, it was transnational gangs, human traffickers, opioids epidemic. And the first question out to the group is this, and I'll ask for a show of hands. Have the announced priorities changed the types or numbers of cases prosecuted out of your office? Show of hands that they have changed the types and numbers of cases that have been prosecuted in your office with regard to those specific priorities. Okay.
Sort of halfway.
John, take it away. How so?
Oh. Well, I think the impact on immigration cases and the number of immigration cases and how much our resources are going to be allocated to that, it's probably going to be increasing as we go. I don't think we've seen a tremendous shift yet. I know that there is a renewed enthusiasm on the investigative agency side to provide us with those referrals, but we haven't really seen in Atlanta much of a uptick on those yet. As for the other priorities, I think with violent crime, with gangs, opioids, the rest of it, those were already our priorities within the office. And we were dedicating a significant amount of our resources to those priorities already. So it really hasn't shifted the needle a whole lot. I think if we were to see on the margins in Atlanta, we might see a slight increase in the number of standalone gun offenses that we had been kind of trying to focus our resources on the most violent repeat offenders in the community as opposed to kind of a standalone 922G felon in possession or alien in possession. So I can't speak for my successor about where that's going to come, but that would be if I were betting man, that would be where I would see some additional resources. But as we were talking, and this is again just in Atlanta because I know my colleagues have had some minor tweaks to that experience, as far as this crowd goes, it really hasn't had any impact whatsoever on the resources that we have in the office.
Well, we'll get to that. And I will say, John, before we started, you got everybody together.
That was short.
And you
short.
said, whatever you do, keep your answers
That was
short.
short.
And now I know the reason why is so that you can talk.
No, that was short.
Okay,
But
so,
anyway.
Beth,
It has shifted our criteria. We had a criteria in place for immigration where we focused on their criminal record, looking for, significant violence or, community havoc. And we were looking for 3 or more prior deportations, and now we're looking at each individual case and taking what the Enforcement Removal Office brings us. On heroin, we have dropped any kind of screening criteria. We will take any heroin case, particularly if there's a gun involved. And we have the resources for that. We don't find that we don't have sufficient resources for either one of those changes. So yes, and then we don't have, we have violent gangs, but we don't have MS-13. So it has shifted our criteria to enable us to take more cases.
Jill, are y'all doing things different?
Not really. Our experience is very much like Atlanta's. We may pick up a little bit more on the 922G firearm cases, maybe an uptick in those, but we haven't shifted resources. We continue to keep the resources in place that we had previously and haven't seen any effect, really. It's been absorbed.
Pete?
Basically the same thing as what Jill and John said. We've had a pretty large uptick in our immigration cases. They're up by 21% over last year. We're taking a lot of, just about whatever was sent to us by way of an immigration case. The other things have always been priorities with us, and they have not changed. Our stats in those cases remain pretty level. The thing about the immigration cases is they are usually pretty quick cases to handle. So as to this point, they've not really taken any resources from us. We're able to increase those cases and still keep everything else at the same level. We'll see how that works out as we go along.
I'll say in Savannah, one of the things that the Attorney General said when he rolled out this is going to be the U.S. Attorney's priorities, he said some of your offices have already seen the uptick, some of your offices are already going after violent crime. In Savannah, we had a 50% increase in violent crime from 2013 to 2015. We got a letter from Loretta Lynch when she was the AG that said, you, Chicago, Baltimore, and 3 other cities, which included Savannah, y'all have seen an uptick in violent crime, so what's going on? What can you do about it? And so in 2016, we actually prosecuted 50% more violent crime cases out of the Savannah division than we had in 2015. And then in 2016, we're going to shatter that record as well. So it's a significant amount of resources in our office are being sent towards addressing violent crime problems, not only in Savannah, but also Brunswick and Augusta as well. I will say this, we have 26 attorneys, several of them are civil. We have every single civil attorney that's handling a violent crime case in our office. That's how much efforts we're putting towards violent crime. And now we are at a white collar crime conference, and it is 20 minutes after we started speaking, talking about federal priorities, and we haven't mentioned fraud whatsoever. And so that's the question. What is the department going to do with regard to going after white collar crime? And I heard from a number of criminal defense attorneys throughout the state, throughout the Southeast, when this administration came in and said, what in the hell is going on? Are you guys going to prosecute fraud? And it wasn't until, like I said before, I get all the national press releases, it was not until April 24th of 2017 when the Attorney General was speaking to a group of compliance folks when he said this. Basically, we can do 2 things at the same time. This was, as far as I know, the department's first pronouncement on going after, continuing to go after white collar crime. talking first, in the first sentence, he's talking about before all of the other priorities, violent crime, cartels, whatever. These are important priorities for our department, but focusing on these challenges does not mean we will reduce our efforts in other areas. And then he goes off and with the list of the types of fraud that the Department of Justice will continue to go after. And then one question was with regard specifically to the Yates memo, and I know that there's going to be a panel next talking about the Yates memo, and further in his speech, and in concluding his speech, I think he specifically addresses it. Let me conclude by briefly making two final points about our approach to this work. The Department of Justice will continue to emphasize the importance of holding individuals accountable for corporate misconduct. That was individual accountability that was addressed in the Yates memo. Not sure if they're still calling it the Yates memo or not. Also, when we make charging decisions, we will continue to take into account whether companies have good compliance programs, whether they cooperate and self-disclose their wrongdoing, and whether they take suitable steps to remediate their problems. So the question for the group, we've just spent 20 minutes talking about the new priorities and surging resources. Show of hands, has the announced priorities of going after violent crime affected in any way your office's ability to go after white-collar crime? Yes or no? How do you do a show of hands with a yes or no? Not sure. John, has it affected your ability to go after white-collar crime?
No.
Beth?
No, we have more capacity.
No.
Pete?
Not at all.
Are you slowing it all as a result of the new priorities that have been issued from the Attorney General in terms of your fraud prosecutions?
Not that I have seen.
No.
No.
Not as a result of the Attorney General's
Okay.
guidelines.
And that's key, what Pete said. Not as a result of what the Attorney General has talked about earlier. But as we all know, I think as we all know, there has been a significant reduction in fraud and federal fraud prosecutions over the past 10 years. Significant number. Jill, I think you may have some numbers on that to give a little meat to the bone.
Yes. So the trend is correct. It's going down, and I'm looking at some statistics that are gathered from the Department of Justice, and when comparing our 2017 prosecutions, our fiscal year is almost over, but in comparing our 2017 prosecutions compared with those from the same period of the previous year, so we're down about 10% from last year. And they're still much lower, even the ones in last year are still much lower than they were 5 years ago. Overall, the data from the department shows that prosecutions of fraud, white-collar type cases are down 33.8% from the levels reported in 2012. Of course, you know what was happening in the economy in 2010, 2011, so how that skews those numbers is really for discussion, but certainly there is a significant change.
So I think with regard to the numbers that you just listed, there was a report that went out in 2015 that said that fraud prosecutions on the federal side was at a 20-year low. That was 2015. In 2016, it was even lower than 2015, and as Jill just said, it's even lower than it was in 2016. So that's great news for all of you white-collar criminal attorneys. The question that I have for 100 years of federal prosecution experience is why? Why has there been nationwide a decrease in the number of criminal fraud cases brought by U.S. Attorney's Criminal Division nationwide? And do you see it in your own districts? Beth?
A number of factors for our district. IRS is the agency that we want on our complicated financial cases, and they do not have as many agents to devote, and they're spread thin. Also, 2011, 9/11 was just a few years ago, and the FBI resources have been diverted to terrorism, both national and international. Secret Service just got through an election cycle and they get pulled off. They are our primary agency for the bank fraud types of prosecutions. And so they're getting back into it now. And our cases are bigger, and I'll let some of the other guys talk about that. But our, for instance, on Roof, which is our, most significant case over the last couple of years, we had 2 lawyers full-time for a year working on that case, getting it ready for trial. We had our automated litigation support full-time on that case for a year to get it ready for trial. And when you make bigger cases, you have more impact, I think. You catch the web, but you can't do as many of them.
John, since y'all don't do fraud cases, I've skipped over and gone to,
In our district, and Charlotte, as you know, is a financial center, so we put a tremendous amount of resources toward the prosecution of white-collar cases. About half of our criminal division is focused on white-collar cases. Because for so long, the cases that we were taking were large, we were assigning a couple of lawyers to them. I think that affected our ability to build cases because we had large, complex cases, enormous discovery, and so it took 2 lawyers to manage the case. And I think that has affected it. I think as well that you may or may not know this, but the FBI has to every year assess their what's called a threat banding process, where they look at what are the major threats in this particular area. In North Carolina is one taken as a state as whole, and I think it's probably the same for everybody else. And so they say, where do we need to shift our priorities based upon the crime that's occurring in this area? And so obviously when that happens and they see under the uniform crime reports, we see the violent crime has been going up steadily. I think, Jim, you talked about since 2013, we've been seeing some increases, and so the FBI naturally is going to shift their resources into their Safe Streets task forces or other mechanisms. In North Carolina, the FBI is focused a lot on public corruption as opposed to your typical fraud cases and healthcare fraud cases that maybe they were focusing on before. I agree. Secret Service being pulled off for a really long election cycle has affected the cases. The IRS has changed the way that they're assigning their CI investigators. They are not moving them typically more than 50 miles from where their home is, where they enter on duty to save. And so that is really creating some unequal balances in where the criminal investigators are for the IRS, and certainly in our district they pair up with FBI or even work cases on their own. We're down in our numbers of IRS agents. So I think all of those things together are affecting the number of cases, and they're definitely down in our district.
I kid John, and John and I are good buddies, but I'll say they've handled some of the largest and most complex cases.
You don't have to retract that. You said what you said. Everybody heard it.
So with that,
He's
John,
dropping the microphone.
you tell me, with regard to the nationwide decline, have you seen it in your office? Do you have any additional factors as to why there is this decline, other than, we don't have enough IRS agents, we don't, the agencies are struggling in terms of bringing white-collar crime.
Right. And there are several former U.S. attorneys from Atlanta in the room right now, so not that I would be critical of there is a difference, I think, in both the type of white-collar practice that occurs in federal courts today than 20 years ago, without any differences in our office. We have more fraud AUSAs in the office back when Joe and Rick were leading the office, and I would say, yes, that we're doing fewer fraud cases than when they were leading the office. I don't think it's a substantial percentage as what's reflected nationally. And I will say that I think our public corruption cases and our cyber cases in particular,
to the Office of Professional Responsibility regarding discovery issues has gone up, and it scares people. I think it has made some AUSAs back away from cases for fear of making a discovery mistake. When you're dealing with millions of documents, electronic discovery, and often there's someone who's in a big case like that hired to handle the discovery for a defense team when there are numerous counsel. They feel I think it can have a chilling effect to some extent.
And my position with regard to fraud cases and prosecuting them is that you could investigate a white-collar case to death Okay, there's always another strand of fraud that you could go down. And I think the key for U.S. attorneys' offices, U.S. attorneys, and prosecutors in general is when do you have enough and when you can just pull the trigger. And you've got to put AUSAs on cases that are willing to pull the trigger. And have you seen every single email that is out there? No, you've run your searches. It's terabyte of information. But I don't want to hear from AUSAs that, hey, we're going to go down this different route, and it's going to take us another six months. You got the ability to prove beyond a reasonable doubt. That other stuff is coming in for sentencing, period. And that's how I think you move fraud cases. So, go ahead.
One final comment on that. I think to pony off of what Jill said, and in our experience in Atlanta, we do see on the AUSA side, I would put the trepidation not so much in bringing the charges, indicting the case, but they are much more careful in litigating the case and conducting the discovery and getting through the voluminous electronic data records that are now part of the case. And we do have a more regular practice of assigning a group of attorneys, whether it's 2, sometimes even 3, to work on the case together so that there is that less likelihood that a mistake is made on discovery. We are spending a lot more time on making sure that we're compiling and doing the discovery right. And I do think there is a trend, to be honest, in the defense bar about litigating these cases with a recurring and regular accusation of any mistake being prosecutorial misconduct. And I think the more and more that happens, the more care and the more attention AUSAs are going to feel they need to spend. And we have spent a tremendous amount of time in our office on our discovery policies that go beyond some of what the department says. But if every single case is going to have an allegation of not just a mistake, but intentional prosecutorial misconduct, then this is, I think at the end of the day, it's going to affect the way that the cases are litigated and the way the cases are prosecuted.
I guess following up on the discovery statement, and I'd like to hear from the panel. You know, each office has their own discovery policy. You know, we were required to have written policies, I believe, back in 2010. Do you believe that you're having a more of an open file discovery policy moves fraud cases faster? Pete?
I think so. I've always been of the opinion that if I'm ashamed to show that my opposition my case, maybe I ought to be taking a better look at my case. I want to echo what Jill and John said. I think that the fear of being accused of not properly complying with discovery slows cases down a lot. We've got some young lawyers in our office. They're very computer literate. They're very aggressive. They're very smart. They enjoy these kind of cases. They do not shy away from getting in there and plowing through the work. But then with our responsibilities under Brady, Giglio, under the general discovery, they slow down to make sure that they haven't inadvertently done something that's going to make them look bad. I mean, the basic policy in discovery, in my opinion, is do what's fair, in doubt, turn it over. I mean, it's a pretty simple process, but it's very easy in these cases to miss something and be made to look like you intentionally didn't try to turn something over that you should have. So I think that slows things down more than anything else. We've had a recent case where we're under the gun with the statute of limitations, and it's been very interesting to see when people don't have the ability to put something off, you've got to move, how fast one of these cases can be made to move. That's been an education to me, and I'm going to try to figure out how to instill that in some future cases. But I do think that boogeyman that's out there does make cases slow down, not because people mind doing the work, because people don't want to be unjustly accused of anything.
Jill, what's y'all's discovery policy in Charlotte?
We have an extremely expansive. I mean, we basically turn over everything short of deliberative product, work product. And so it's very expansive. As I said, we have letters in place to cover it because we're gonna dump it. We're just gonna give you a huge dump, which what we have tried to do is catalog what we're turning over. Everything's searchable. All our electronic, we get it electronically, it's gonna be searchable, and it's gonna be broken down into subject matters, FBI 302s, whatever the case may be. So we are trying to help move things along whenever we produce the discovery too. We've tried to be as advanced as we can in that way.
Beth?
I don't think that our discovery policy has expedited the tract of the case. The index is very helpful, and we actually send, or they go, our automated litigation support will go teach some of our bar members how to navigate the material. We will sit down with defense counsel and show them our case. So I think the cataloging and working with defense counsel helps.
You know, in the Southern District of Georgia, we've had, as many of you know, we've had an open file discovery since the 80s. Hand over grand jury transcripts, memos of interview at arraignment. So I've actually found in all number of cases, not just white collar, that moves cases along. I also believe in large white collar cases, we'll do reverse proffers with attorneys, pre-indictment, to say, hey, this is what we got. Judge William T. Moore Jr., who recently took senior status in our district, when I take over an AUSA to meet with him, every time, he's a former U.S. attorney, every time, one of the lines that he says is, I've never seen the government lose a case because they've given over too much information. And so we're giving over, a tremendous amount of information, and I think it helps move cases. I also think that judges help move cases as well, because as you all know, and as we all know, continuance after continuance in fraud cases is common. It's not common in the Southern District of Georgia. I know a few of the attorneys out here were involved in the First National Bank prosecution, where we charged 7 former officers of a failed Savannah bank. And Judge Wood, who was the chief judge at the time, we had one of the defense attorneys who filed for a continuance because she had cancer. And the judge granted about a 2-month continuance to get somebody else up to speed in a case that involved over a terabyte of information. I mean, our judges do not sit on cases, and I think some of the reasons in terms of moving large fraud cases can be put on the judges as well. So we talked about changing priorities and the effects that it has had in the cases that we have seen. The decline in the number of federal criminal fraud cases that have been brought over the past 10 years. There is has been another significant change that has been thrown out by the Attorney General recently, and that is his policy on charging and sentencing. I think I've been in the office in the Department of Justice since Ashcroft, and it seems like every incoming AG has to have their own memo with regard to charging and sentencing. So it was the Ashcroft memo, it was the Holder memo, and now it's the Sessions memo. And for a brief description on the changes, I'm handing it over to my good friend, Mr. Horn.
And I will be brief. My point is that I would like to make the case that the Sessions memo actually is much more similar to the Holder memo than I think has been largely reported in the media and the reaction to it. Jim's right. The bouncing back and forth historically between the attorneys general about the different charging policies. You've got Thornburg that says no discretion, you have to prove the most serious, readily provable offense. Then you go to Reno, and it says you make an individualized assessment about the facts and circumstances of each case and celebrates the discretion that prosecutors have. Then we go back to Ashcroft, and there's less discretion. With Holder, there's no doubt there was a return in a large way to the Reno philosophy of individualized assessments about cases. But where there was less discretion was in cases involving recidivist enhancements or mandatory minimum enhancements within statutes, mostly in the drug cases or in gun cases. And in those cases, there was sort of a presumption against charging the mandatory minimums. It was, you shouldn't, but if these factors are existing, then you can charge and should charge the mandatory minimums. Under the new policy under Sessions, it's really kind of a reverse presumption. It is, you should charge these mandatory minimum cases with recidivist enhancements for drugs or multiple 924Cs. You should charge them unless. So in the fraud arena, in the white-collar arena that concerns most of you, it is my belief that the Sessions memo really makes no change whatsoever to our discretion, to our presumption, because under both Holder and under Sessions, you start out with the first thing that the prosecutor does is determine what is the most serious readily provable offense. That was true under Holder, and that was something that our office was doing under Holder. We did start at that same starting point. And then the question is there something about the case, in the facts and the individual circumstances of the case, that encourages us to exercise our discretion? That also is true under Sessions. And I know that when Sessions came out, the media and a lot of folks focused on the paragraph that emphasizes the importance of the most serious readily provable offense. But if you hear Attorney General Sessions, or especially Deputy Attorney General Rosenstein, talk about the memo, Rod Rosenstein says his favorite paragraph of the memo is the third paragraph, and that paragraph explicitly says that there are times when a prosecutor exercising discretion, looking at the facts and circumstance of the case, may make something decision-wise that is different from the most readily provable chargeable offense, and that's true also with sentencing. So it's my position, and this is how we have implemented the memo in our office, that really there hasn't been much of a change from Holder to Sessions, with the exception of the mandatory minimum cases that we talked about.
So I'll open it up to the panel, but I'll say first that, and this has been widely reported, so it's not inside baseball. The original draft of the Sessions memo was 5 to 6 pages long. And it was described as the Ashcroft memo on steroids as it relates to the number of 924Cs, the 851s. It was really a recipe of charging, particularly charging. And Sessions himself personally marked it up with a red pen and reduced it to a page and a half. And stated, I wanted to do that to give the most amount of discretion to U.S. attorneys' offices that are actually in the field. And so the question is, for the panel, has this memo changed the way y'all are doing business? Beth?
It has in the drug and violent crime arena. So I agree with John. The discretion under the Holder memo, we were asked to use our discretion on whether to charge. And the Sessions memo, we're using it on the back end. So we charge the recidivist enhancements, the multiple 924Cs, and then it's incumbent on both the prosecutor and the defense bar. It heightens the burden on the defense bar to make sure that at the end of the process that we've gotten to the right place and that the court has the tools to impose a sentence that's fair and not overly emphasizing a conviction over danger, future danger. So it has impacted the way we charge in the narcotics and violent crime arena.
Jill, before you say that, the argument goes, I'll ask you to comment on this, the argument goes as it relates to this possible effect on fraud cases, is that if you charge the 851s, if you charge the mandatory minimums, everybody's going to go to trial because you can't give them a break. Has this memo changed with regard to the way you do business, and do you see that effect tying up resources because we're charging at the front end the 851s and the additional multiple 924Cs?
It hasn't changed much in our district. Most of the cases we were charging fell under one of the Holder exceptions anyway. Were they a gang member or a cartel member? Were they someone who had a significant criminal history? You'll recall Holder had a lot of exceptions as to when those mandatory minimums were to apply. And so we were already doing a lot of that work anyway through our screening process. So it hasn't affected us too much. As far as whether it's affected our ability to try fraud cases, I do not think it has. I will say, and you guys probably know this as well, that statistically, across the country, we're trying a lot less cases than we used to, and a number of our judges have said we want more cases, we want more work, we want more trials. And so I haven't seen in our district where it's had any effect either from a charging perspective or on the backside at the trial level.
Pete, what effect has this memo had, if any, in the Middle District of Georgia?
It's had very little. As far as white-collar cases, it would be none. It affects mainly the gun and drug cases, like everybody said, and our statistics have remained essentially the same. I don't see where we're trying more cases in any category than what we were before. So the main thing was it was a big morale booster for our drug prosecutors. They like the new policy a whole lot better than they did the old.
There's one sentence in the memo, second paragraph from the bottom, that may or may not have an effect, I think, on criminal fraud prosecutions. And I think John in the Northern District is already doing this. But the statement is, consistent with long-standing Department of Justice policy, any decision to vary from the policy must be approved by the United States Attorney or Assistant Attorney General or supervisor designated by the U.S. Attorney or Assistant Attorney General, and the reasons must be documented in the file. And so, okay, you got a criminal fraud case, and the guy's looking at a guideline range of in the neighborhood of 10 years, and you're going to give him a 371 conspiracy. Well, why are you going to give him a 371 conspiracy? Well, because maybe I want to move cases. Is that what you're going to document in the file, and is that significant enough for you to be handing out a 371 conspiracy in a fraud case? I think all of us think, and we've gotten some indications, that there is going to be reporting requirements associated with this memo relating to whether or not there's been compliance with the memo, and specifically with regard to, and the reasons must be justified in the file. In the drug and gun case, it's simple. Hey, this guy's going to cooperate. Oftentimes in the fraud cases, this guy's going to cooperate. But, you know, you may get some pushback from some AUSAs when you say, hey, man, give me a 371, help me out. And the AUSA may take it up to the supervisor, and the supervisor requires, well, give me your justification why we are going to not go after or not comply with the Sessions memo. So we've talked about two areas of transition: priorities, the charging and sentencing memo. Ms. Brand talked a little bit about the changing, the transition in each and every U.S. Attorney's offices. I think only in the Middle District of Georgia and Northern District of Georgia has there actually been a nomination. In South Carolina, no. Southern District of Georgia, no. Western District of North Carolina, no. But within, like I said, within the next year, we're all going to have different bosses. And to tell us how that affects U.S. Attorney's offices in terms of how cases are handled, we're going to go to the guy who has taught more U.S. attorneys how to do their business than anybody else sitting on the panel, and that's Pete Peterman.
Well, thank you, John. Jim, it's very idiosyncratic. I've been through 5 U.S. attorneys now. I've been the first assistant for 3 of those, and a lot of it depends on the U.S. attorney. We've got prohibitions on contacting someone once they are identified as a potential nominee. And I don't think the rules are as strict as everybody acts like they are. There's virtually no contact between us and anybody who's rumored to be likely to be appointed until after that appointment is made. And if it's someone in the office, obviously there's going to still be contact, but that's very awkward, and we've had that happen a couple of times. But one of the things that affects is how the U.S. attorney feels about the office when they come in, because we can't talk to them, but everybody else can. And so people that have an AUSA they don't like, or a particular program they don't like, or a person they particularly want to push or punish, will talk to the prospective United States Attorney. There's no prohibition on them doing that. So a lot of it depends on the attitude that the new U.S. Attorney comes in with. The other thing about U.S. Attorneys is it's a very unique position. And of course, Joe Whitley or Rick Dean probably ought to be addressing this more than I, because they've been through it. But you know, it's a limited term position. When you come in, you know you've got maybe 3 or 4 years, maybe 6 or 7 years, but you don't know which. And depending on what your goals are in the attorney, that's as the U.S. Attorney, that's a very driving factor in what you do. On the office, it has a big effect because everybody wonders what are the changes going to be. Jim's talked about a situation where they had a new U.S. Attorney come in before he came to the U.S. Attorney's office doing defense work, and his client had pretty much been dropped and forgotten, so his firm thought, and the next thing they know, they're being notified that his client's been indicted, because the new U.S. Attorney looked at that case and said, we need to go forward with it. Our office doesn't change a lot. The first assistant, who was first assistant before me, was in that position for about 15 years. I've been in it for 19 years now. But a lot of times that change takes place immediately. We had one U.S. Attorney come in and take out a long-standing criminal chief that created ripples in the office which lasted for 10 or 12 years after that happened. So you have to be very much aware of what they're going to do. As far as dealing with new U.S. attorneys, I actually spoke a little bit out of turn when Jim asked if I sat in on all the grand juries. As first assistant, I do. As the U.S. Attorney, I simply haven't had the time to do that. The person who's serving now as first assistant does that in my stead. I would recommend to a new U.S. Attorney, they can't afford to do that all the time, but the first 2 or 3 grand jury terms, I would recommend they do that. If you have a U.S. Attorney who's never worked in the U.S. Attorney's office, they've never seen a federal grand jury in action. The biggest change I find everybody has coming to work for the federal government is the fact that a high level of praise or respect is paid to inefficiency. The government has its way of doing things, and it's different from anybody else. I think I'd worked for the government about 3 or 4 years when my wife said, it's a big river and you can't keep swimming upstream forever. You got to just understand that's the way it works. That's some of the best advice I ever got in my life. And I think U.S. attorneys, particularly former DAs who are elected and they're used to running their offices, they're a managing partner in a law firm, they come in and think, well, they can speak and that's something that's going to happen. And they're unaware of the layers that you have to go through with a lot of stuff. One of the other things is getting to know the people in the office. I think that the department over the years, and I think in this term is going to do the same, is encourage U.S. attorneys not to make a lot of changes when they first get there. Stick around for a few months, get to know the people, get to know your management team. I think especially the relationship between a U.S. attorney and a first assistant is very important. First assistant, on the last 2 U.S. attorneys we've had, when they came in, I met with them every single morning. We talked about what was going on in the office, what was coming up that day, and some topic that thought the U.S. Attorney needed to learn a little bit about, be it budget, be it the personnel management system, whatever it was. We also have all of our AUSAs write a 1-paragraph biography, and we give the U.S. Attorney a book that has a photograph and what this person had to say about themselves in it. And encourage the U.S. Attorney not to, we did this one time, the U.S. Attorney sat down and had everybody in about a week's period. You're talking about 60 people. Well, we had a very confused U.S. Attorney at the end of that week. That doesn't work very well. But talking to, a half dozen people or so every week, going down by their office or whatever, meeting them, talking to them. We have monthly all-hands meetings that we instituted specifically so the U.S. Attorney would be seen by everybody. We have weekly management meetings. And it's mainly trying to introduce them to a new system and just to provide guidance. The U.S. Attorney is going to, a good U.S. Attorney is going to provide the impetus, this is what I want done. And it does make a big difference in the office. When our last U.S. Attorney came in, we had no ACE practice to speak of at all. Right now, that's the most active practice in our civil division, is our ACE practice. What the U.S. Attorney wants to focus on will be focused on. So they have a great impact on the office, and plus the leadership qualities of the U.S. Attorney.
Jill,
that's probably the most important thing.
Pete. Jill, picking up on what Pete was talking about in terms of transition and making changes, what information do you have in that regard?
The latest information we have is that whenever the U.S. attorneys come in, they won't be allowed to make, they will not be recommended that they make immediate changes until they've been to an orientation session. Orientation sessions are going to be held once they have a group of people to go through. They're going to strongly discourage immediate changes because it is quite a behemoth and a lot of layers to understand. You may not know, if you haven't been in U.S. Attorney's office, you can pick who you want to be your supervisor, but that doesn't mean that's going to happen because it has to be approved by the Office of General Counsel at the Executive Office of U.S. Attorneys. And so each of those management selections are vetted for competency and quality of practice or whatever they're looking at to make sure that they're appropriate to be in that particular position. That will happen as well with the new U.S. Attorney. So I say that you shouldn't expect immediate changes, whether you want them or not, that it takes a minute for things to go through the processes that the department puts in place to ensure there is calm and continuity.
Beth?
So our office, we have 4 offices across the state, and they're staffed by very experienced career AUSAs, and I'd like to take credit, and I'm sure all the U.S. attorneys would like to take credit for managing them, but it's to some degree herding cats. I mean, they are strong, and they have definite interest in talents. They are terrific trial attorneys. They're aggressive, and so I don't expect, you heard from our U.S. attorney, our past U.S. attorney this morning, Bill Nettles. He built our KETAM unit, and our bar loves it.
So he built your KETAM unit, and now he's doing KETAM work.
Yeah, he is. And funny how that works, huh? But, so I don't expect that to change. When I became the acting, immediately shifted resources to violent crime because that's what the kind of practice that I grew up under in the U.S. Attorney's Office, and we needed it. So when they walk in, the new U.S. Attorney walks in, we will welcome them with open arms, and they will have a honeymoon, and they will have the opportunity to hire at least 4 AUSAs off the bat, and they will be able to put those AUSAs towards the priorities that they're interested in.
So it is a him.
Oh, that was sexist.
Okay.
Excuse me.
Anyway, one bit of change, I think, and I was talking to Joe. He said he's never heard of this before, and I think this is significant. I know Jill's talked about that it appears that they're not going to allow changes in management initially when somebody comes in. But every U.S. Attorney's office across the country has been told, and they have done it, they have to reserve a full-priced salary AUSA in case the U.S. Attorney coming in wants to bring in his own first assistant. And I don't think that that's been the case in the department that I know of, that it's ever happened. Certainly, U.S. attorneys have come in and appointed their own first assistants. Many times it's from the office, but we've been told to make sure that in the budget is a full salaried AUSA.